Hello, my name is Lee Presser. This is my show. I speak frequently to very interesting people. Some of these conversations are so exciting, so intellectually stimulating, I thought others might like to listen in. This is the reason we started recording Conversation with Lee Presser.
Welcome to Conversation with Lee Presser. My guest today is Tad Armstrong. He's the founder of ELL Constitution Clubs. ELL means earn it, learn it, or lose it. The ELL concept was established to bring an understanding of the United States Constitution to as many Americans as possible. From January 2010 to July 2012, Mr. Armstrong wrote a monthly opinion piece which was printed in the St. Louis Post-Dispatch. His commentaries spoke to constitutional limits on government's authority to take certain action. The Post-Dispatch recently terminated the column. Today we're going to talk about that terminated column and talk about the impact of recent Supreme Court decisions. We'll also be discussing Mr. Armstrong's speaking tour and his book. Tad Armstrong, welcome to Conversation.
Hi, Lee. Good to be back.
Yes, it's great to have you back. Last time you were a Post-Dispatch author, now you're not.
It was. That's
true.
So
the editor of the St. Louis Post-Dispatch commentary page was here. He addressed that issue. I believe that you have heard that explanation.
Mm-hmm.
I'm just going to give you an opportunity perhaps to respond.
Well, let me just say that first of all, I considered it such a privilege to have that ability to write once a month for a well-known paper in our community. I miss it really a lot. It was a form for me to vent, actually, in my opinion. When you don't own a printing press and you have that opportunity, it's just really, really hard to lose. I've got nothing bad to say about the Post from the standpoint of how they treated me. Interestingly, although they had the right to edit my pieces, on occasion they'd catch a typo of mine, which happens with all of us. There was only one occasion they changed the substance of a word that I thought was critical, but other than that, never got any praise for my pieces, but I never got any criticism either, and they let me have full reign, and it was a really good run. I think, I don't know who can get in the mind of those that make these decisions. Mr. Messenger indicated that he thought I didn't bring anything, I think, new to the table that Krauthammer and George Will were not already doing, and that kind of thing, and I guess that's fine. The last piece I wrote was severely critical of the Democrats and the walking.
Think that might have done something?
Well, I don't know. Like I said, I don't know. But it was a piece about most of the Democrats, all but 17 of them, walking out of the hearing when they when the Republicans, for the most part, moved to hold Eric Holder in contempt on the Fast and Furious issue. And the fundamental point of my piece was Senator Clymer, a Democrat, indicated that it was overkill, it was a witch hunt, and my piece basically said, no, I view this as underkill. Apparently one dead American doesn't make it worthy of investigation. But if 100 Mexican thugs had come across the border with 100 guns we'd given them and wiped out several of our Border Patrol and the city of El Paso's founding fathers, or aldermen, it'd have been a different story, don't you know? But the same principle is there, just not enough crisis for the Democrats to react. So I was pretty severely critical of the whole situation, and that was the last article I wrote. Who knows?
So we've covered that subject. You've had an opportunity, and see?
It was a good run.
At least you have had an opportunity here, even though it's not in print, you have an opportunity to respond.
31 months was I had a lot of fun.
Oh, yeah. Did you get, I wanted to ask you, did you get many letters to the editor regarding some of your articles?
Well, you never know. I mean, occasionally I had them send them to me, saying that they probably...
Well, I should say, did they print letters to the editor?
They did on occasion. You never know, really, what comes in after an article, how much favor you and how much don't. But they put in both sides. Yeah, they did.
Mm-hmm. Okay. So let's cover this other. You've written a book, and you're on a speaking tour.
Yes, just beginning.
So let's just talk about that right now, and then after that, then I want to talk about ELL, where that stands, and some recent
decisions.
Some recent Supreme Court.
Thanks for asking about the tour. I was so frustrated that Lee, our country is ignorant. It's just a sad state of affairs. Jefferson said, if we do not maintain our education, we'll lose our freedom. And I believe that. The most frustrating part of this to me, and the reason I had to write this particular book, was about the religion clauses of the First Amendment.
What's it called?
It's okay to say God.
Okay.
And that title might be a bit misleading, I think, when people get into the various topics, prayer in school and Ten Commandments, and all the topics you can think of. They might be a little bit surprised at my conclusions. But the point is, the reason I wrote it, nobody seems to be getting this right. And I had to set the record straight. And so I'm hoping to go on a tour of starting really soon. All my marketing material is almost finished. I can't wait to show you the DVD sometimes. But we're going to be touring the country and speaking in predominantly churches about these issues and hoping to educate folks of all walks of life. I mean, atheists need to know this material and other denominations and religions because we must stay educated. We must.
Did you want to give a synopsis of your conclusions, or would that ruin your book?
It would take too long. But what I delve into is the proper interpretation of the Establishment Clause and the Free Exercise Clause, and the concept that it's not. On the left would have us believe that the word God can't even be mentioned. We can't mention God in an elementary school or the Creator in the Declaration of Independence. That is just absurd. On the other end of the spectrum, I think that conservative Christians would find it surprising to know that I say, look, you need to stay out of government when it comes to symbols, nativity scenes and such, because the manner in which the Supreme Court has interpreted this only speaks of trouble and turmoil when it comes to religion. That's exactly what the Founding Fathers intended to prevent. So that doesn't tell you much about it really, but there's no time, I think, today to get into the details.
Sidebar, the recent Democrat convention had some issue that came up that some in the press made a big deal about. There was the original platform deleted the word God from the platform, deleted also American support for Jerusalem as the capital of Israel.
Right.
They had a voice vote before the convention, and it was just embarrassing for the Democrats. And there was that word God again.
Yeah. It's difficult to tell from watching television which voice vote won, but from my perspective, if all we look at is how the TV is reporting the volume, the no's had it. But they overlooked that. Apparently this president can make a phone call and overcome his own rules of his own party. And they put it back in.
Well, you know, the chairman or the Speaker of the House or whomever, they make a decision. Of course, if you want, you can then, and I don't know what the rules of the Democrat Party are, but you can call for a roll call vote.
2/3 voice vote.
Right.
That wasn't there.
No, there wasn't 2/3.
Unless you're in the hall. Unless you're in the hall and the voice votes came off differently than the television.
Yeah.
But TV, it wasn't there.
Right.
Yeah.
So now, where are you going to be touring to?
All over the nation.
Do you have a schedule yet?
I don't have a schedule. I've already spoken at 3 venues. And like I say, we're just getting our marketing materials together within the next week or so. And then we'll be seeking people to let us in their doors.
Well, I just want to point out so that people know, this is September 11th of 2012, so that when this program airs in about a month, that's why it sounds like this is maybe they've seen something in the paper that's like, wait.
Hopefully I will have already spoken at several venues.
Are you doing St. Louis?
Oh, sure, yeah, right. And by the way, since we're on this topic for now, I'm one of the cast members of a 1-hour television special to be aired on Fox Business Channel on September 30th at 4 p.m. Central Time about the intersection of church and state and these very issues upon which I wrote my book.
That's interesting.
Yeah.
Well,
the premiere is, for those that put this together, is in Wildwood on the 17th of this month. I can't wait to see it.
that's right, 17th of September,
Yes.
which is already
Yes.
passed now. Well, unless people are seeing this on YouTube, in which case it's not in the past.
There you go.
Okay.
Yeah.
So
Yes.
now that we've covered that, let's just review for those that may have missed you in the past. ELL. I tried to explain in the introduction what ELL is. How did this briefly tell the story again? How ELL came into existence?
Well before anyone started seriously talking about the Constitution and
or the Tea Party,
and our
This
roots,
is-
or the
we've
Tea
been
Party.
talking about this since
I started this in the fall of 2004.
I was going to say we talked about this long before President Obama became president.
Right. Well, again, frustration. Attend a coffee shop pretty much every morning and overhear people talking. One of the favorite topics is the Constitution and the law. And well-intended people were getting it so wrong that I received a challenge from a local businessman that I need to educate folks. And we started, and lo and behold, that seed turned into clubs all over the Metro East. And a very intensive program. By the time people are through it, they read over 300 Supreme Court opinions and meet monthly and so forth, and it's been just a wonderful experience for me. I'm going to turn that into some DVD presentations of much like a 13-week, 13 one-hour DVDs that I think will serve my purpose much better. 4 years once a month is a bit of a challenge.
You need, if I might suggest, to really start aiming at the publishers of school books and see if you can't get them to distribute them into schools, because young people need, not just young, not every, how do I put this? Everybody needs to know this, but it would be better if you could get school kids in those courses where they're supposed to be learning about government to have this this information.
Right. Good idea.
Yeah. So now let's talk about the Constitution of the United States. In the Constitution, I'm looking for, but I can't seem to find any reference to executive orders. Where am I missing that?
Yes, you won't find any reference to it. Lee, we're in a crisis in this country. The Democratic-controlled Senate seems to pay no heed to this president when he dramatically exceeds his constitutional power. And the Supreme Court of the United States, on a much more frequent basis than there used to be, seems to be exceeding its power as well. And I think we're at a crisis stage. Executive orders are not in the Constitution, of course. Both parties have used them in the past, but this president seems to believe that he has no limits to his power, and he's getting away with it.
I explained this to several people in this way, and correct me if I'm wrong, but my understanding of how executive powers came into being and what they are was that President Washington assumed this power, and it was actually he telling members of his administration, like he was the owner of a business, this is how we're going to do things in this business called the Washington administration. And that's what an executive order was, is this is the process that I want you to follow. But it appears now that after 200 years of the development of executive orders, it almost appears to me to be a royal command.
Well, when you have a president who, by executive order,
and I'm not just saying Obama. I've seen
any
presidents going back to numerous presidents into the past. The power of the presidency just seems to be increasing. I'm going back, you go all the way back to Nixon, to Ford, to Carter, Reagan, Clinton.
I think the problem began when Congress turned over its responsibility to administrative agencies and permitted them to set up all kinds of regulations that really made law as opposed to implemented law, and from there to
Explain what the
executive
Federal
orders.
Register is to people.
Oh, well, the Federal Register is a compilation of the regulations of administrative agencies, and just for the Obamacare alone, there's 15,000 pages by now, I think, of these regulations.
So this is an official, it used to be a book, but it's an official grouping of where the agencies like the EPA, like Health and Human Services, they publish, this is what we're going to make the rules look like. And they have to publish that because there's comments going to be made on that. And then after the comment period, there might be some revisions, but then the Federal Register almost parallels statute law, doesn't it?
Well, it becomes law. Sure it does. And because of Congress willing to give them that much power. And we were in a situation where the three branches of government that were designed to be a balance of power and checks on each other have merged to the point where there's no check on each other and it's just out of control. It's a serious problem.
So, well, now
the most recent example, I'm sorry, but when the president, when the DREAM Act fails to pass Congress and the president with a stroke of a pen, in effect, by executive order, gets much of it through,
remind people
that is a serious problem.
Remind people what the DREAM Act was.
Well, it was fundamentally designed to grant all kinds of leniency towards illegal immigrants and give them status in this country. But I don't recall the details of it right now, but I just know it didn't pass. And this president decided to implement much of it with a stroke of a pen by permitting those children of illegal immigrants to attain certain status that they don't have otherwise by law. Whether that's a good policy or not isn't the point. The point is it's not within his power to do that. It was an egregious, unconstitutional act, and to my knowledge, it hasn't been challenged by Congress or anyone.
Apparently there's been, well, not apparently, there have been over the years executive orders for emergency powers for the executive department in case of a crisis, of a national uprising or something. Apparently the president through, or I should say, there are police powers that have been handed to the president during emergency periods via these executive orders, which seem to scare some large group or a large minority of our citizenry.
Well, of course, the Constitution does allow for extraordinary powers in times of emergency. And martial law.
Lincoln used these during the Civil
Lincoln
War.
probably overstepped his constitutional limit. That's the problem. When the Constitution is tested the most, when we're at war or have those kinds of crises. The question always becomes, do you exceed the power to preserve something, a Constitution to come back to, or do you abide by the Constitution and stand a far greater chance of losing the nation in the process? Not an easy question in times like that.
So the Supreme Court, here's something I wanted to ask you, and just because so few people seem to know about this. In the article of the Constitution that refers to the Supreme Court, there's one little line in there that says that Congress can prohibit the courts from looking into certain areas.
From a jurisdiction?
Yeah.
Oh, well, yeah. The only court that is established by the Constitution in Article 3 is the Supreme Court. And you know what they say about all other federal courts?
Inferior.
They are inferior, but they are to be set up by Congress.
Right.
Which means, of course, if Congress did not establish any federal courts, lower courts, we wouldn't have any. It doesn't require federal district courts or federal courts of appeal in the Constitution. It gives that authority to Congress. Right. I don't know if that's where you're driving at.
Well, no. I was thinking that that the court system has entered into what I consider political areas and making political decisions that rightly belong in the legislative branch, but they, because the legislative branch has failed to act on these areas, the courts feel impelled, maybe that's the right word, I guess the beginning of it where it really looked like that was some of the integration laws, or back in the 1950s.
Well, of course, yeah, there is
education. I'm forgetting the name of that case.
Well, yeah, but there is, excuse me, there is a doctrine of the political issues that they normally stay out of, at least in years gone by. I would contend every decision has a political element to it, and where you draw the line is not easy. But the court, in my estimation, has exceeded its powers in several different areas, one of which is a fairly recent case, the Miller versus Alabama case, if you want to get into that a bit.
Let's
that held that a mandatory life without parole sentence to a 14-year-old was unconstitutional. Now, it didn't say that it would always be unconstitutional. What it said was you have to give the jury or the judge the opportunity to consider youth in that decision before a sentence is handed down, rather than having it mandated. The problem with that, of course, and we've been doing this ever since 1976 with the Trop versus Dulles case. I should have this memorized, but that's the case that developed this concept called the evolving standards of decency that mark the progress of maturing society when it comes to the Eighth Amendment and interpretation of cruel and unusual punishment. That phrase has overtaken the words of the Eighth Amendment, which gives the Supreme Court an opportunity to pretty much do anything they feel correct from a policy standpoint as opposed to an interpretation standpoint. And this is a case on point. 29 states prior to this decision had laws that mandated life without parole for certain types of crime for 14 years of age up to 17, just under 18 years of age, such as murder or participating with others in murder, felony murder rule. All of those have been struck down with a stroke of a pen.
Mandatory.
Correct.
Right?
Correct.
But
Now,
judges will be given discretion to be able to impose that, right?
Well, now they will be because of this case.
Right.
And it's not a question of policy. It's a question of what is the job of the Supreme Court. When they strike down laws passed by you and me and citizens all over this country, there are times when they should do that, but they ought to be seldom, and because they are taking away we the people from the element of this nation, from our how we understand this country. And we've gotten into this area of the Eighth Amendment where it doesn't seem like cruel and unusual are the catchwords that mean anything anymore. Whether it's decent, not according to the legislatures of the several states, but according to 5 of 9 Supreme Court justices, that exceeds the power they're entitled to impose.
Here in the last 5 minutes, let's cover the, it actually has a long title. I was surprised. Normally it's called the Affordable Care Act, but the court called it National Federation of Independent Businessmen et al. Versus Sebelius, Secretary of Health and Human Services et al.
Yes.
Anyways,
The Obamacare ruling.
It's the Obamacare ruling in which Justice Roberts wrote some things that I know you want to comment on.
Well, I wrote about this law early on when I was with the Post, and I made the comment that if the Supreme Court would turn to the Founding Fathers' intent of the Commerce Clause, there stood a pretty good chance that this would be struck down on that basis. At that time, and I wrote that article right after it passed, At that time, a professor of law in St. Louis wrote a letter to the editor in response to my article and called me either stunningly ignorant or intentionally deceitful. Now, when I saw that, of course, that was my first.
What was his reasoning, or was there reasoning there?
Commerce Clause, I guess, in his mind was basically unlimited. But I felt to be otherwise, and there would be a good chance of it being overturned on that basis. Of course, it was overturned on that basis. By the way, I find it stunningly ignorant or intentionally deceitful for any law professor to state, to predict the outcome of a Supreme Court opinion with that much certainty that he could criticize a fellow attorney with those strong words. Well, anyway, he turned out to be wrong. I turned out to be right. On that issue, surprise, surprise, the Supreme Court, in a 5-4 decision, turned to a different provision of the Constitution, the taxing power. And I think it's a devastating opinion for this reason. It almost gives unlimited power to the taxing clause. Why would Congress need the Commerce Clause anymore to do whatever they want to do, as long as they tack on some sort of a taxing provision to make it, to enforce things that otherwise would not be constitutional? It's one thing to uphold this law on the Commerce Clause and then deal with amending the Constitution. That's relatively simple when compared to trying to amend the Constitution with this taxing ruling, because I don't know how to draft such an amendment. It would be extraordinarily difficult. So what I'm saying is we're in a worse position now. Even if this law is repealed, we still have the case, and it's still out there for future cases to come. It's of great concern to me, and I think that Krauthammer said that he was against the ruling, but he appreciated Justice Roberts upholding the integrity of the court. I don't think he upheld the integrity of the court at all. In fact, I think he turned his eye away from the Constitution, away from his duty. It's a bad decision. One that will come back to haunt us.
Yes. Well, if you go back to the meetings, what we call the Constitutional Convention, which was in 1787, you would find that both of those areas were very controversial when they were written, the taxing power and the Commerce Clause. So last 30 seconds here.
But no, what was not controversial, though, Lee, was that the Founding Fathers believed that there were to be limits on the power of the legislative branch and the power of the executive branch and even the power of the judicial branch.
Right.
That they did not disagree upon.
Yeah, and what they also, when the Constitution moved over to the various states for there to look at and to vote on, many of those states actually came close to saying no.
Oh yes, there was.
Well, unfortunately, we have pretty much run our time. So,
okay.
We'll have you back again. Thank you very much.
We can't go another hour?
No, I wish.
Or another 30 minutes?
Anyways, I got to say goodbye here. I've been speaking with
you.
Tad Armstrong, founder of the ELL Clubs. For those of you who are regular viewers, we'll see you next time. By the way, this is available on YouTube. Go take a look. Thanks. Bye.